right. Good morning, everyone. Those of you who are in the hearing room and those who are participating virtually, welcome. On October 21st, 2025, the clerk's office published a notice of follow-up workshop, and in that notice, the clerk's office stated that the Public Service Commission staff would conduct a follow-up workshop related to procedural issues contained in Act 41 of 2025. The clerk's office scheduled the workshop for today, Monday, November 10th, beginning at 10 a.m. in the Commission's hearing room. And that notice also included some proposed changes to existing Commission regulations, and yeah, all of them are existing this time. The first draft we did, we had a new one, but we deleted that one. Okay, so also, if you noticed in the docket management system and in the workshop that we held in August, I asked the stakeholders to consider some additional topics when we met later. And you may remember that one of the topics dealt with signature and verification regulation 103-822. The other dealt with briefs or proposed orders. Then there's one on the language related to Act 41 and the commission issuing an order within 60 days of the filing. And then we ended up deleting one because stakeholders clarified that the cost for interveners had nothing to do with PSC. That's in the Integrated Resource Plan statute. So that was deleted. May we begin now to see who's here and participating today. Dominion Energy, South Carolina, would you please identify yourselves?
Good morning, Ms. Boyd. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina. With me today is Michael Anselmo. He serves as the company's outside counsel from the law firm of McGuire Woods. It's a pleasure to be here today. Thank you.
All right. Thank you both for being here and participating. Department of Consumer Affairs.
Hi, good morning, Jocelyn. Roger Hall with the department.
Thank you. Piedmont Natural Gas Company.
Good morning, Ms. Boyd. It's Jason Richardson on behalf of Piedmont Natural Gas from the law firm McGuire Woods. I just want to let you know that those of us on appearing virtually are not seeing the video stream from the hearing room.
Okay, thank you so much for making that note. Let me pause everybody for a second. Let's if you allow us to correct that issue. Thank you, Mr. Richardson.
Mm-hmm. Good now.
Okay, wonderful. I really appreciate you bringing that to our attention because we do want to live stream these for anyone who's interested in these Act 41 topics. Thank you so much. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Jocelyn. Sam Wellborn here on behalf of Duke Energy. To my right is Lyle Trawick of the firm Robinson Gray. I have a hard stop at 11 o'clock, and so if we go beyond that point, I may ask that Tekla Henderson sort of swap seats and tag out with me.
All right.
Thank you.
We thank you for being here during the time that you can. Southern Environmental Law Center.
Good morning.
Good morning.
Kate Mixon here on behalf of SELC, and Thomas Gooding is also here virtually as well.
All right. Thank you. And welcome to you both, Ms. Mixon and Mr. Gooding. Next is Water Companies, South Carolina Utilities.
Good morning, Charlie Terraney here for the Nexus Utilities.
Thank you, Mr. Terraney. Palmetto Broadband Coalition.
Good morning, Jocelyn. Nanette Edwards. I'm here on behalf of the Palmetto Broadband Coalition.
Thank you so much. Does Ms. Eaton happen to be present? She may not. The OMRMA did not file comments. However, we noticed her name on our media plan survey, just in case she wanted to participate. Okay, Ms. Eaton is not here. Carolina's Clean Energy Business Association. Okay, Mr. Witt nor Mr. Burns are here right now. And then Mr. Mustian from Office of Regulatory Staff.
Ben Mustian on behalf of ORS.
Thank you, Mr. Mustian. All right, everyone, based on the comments that were filed, I really didn't see any substantive suggestions for changes, with the exception of Department of Consumer Affairs. Does anyone have an issue with us focusing on asking Mr. Hall to proceed first, and then us focusing on Mr. Hall's suggestions, and then see if anyone has anything else to offer. All right, I have copies. And virtual stakeholders, did you receive the email that I sent this morning?
Yes, ma'am.
All right, does anyone not have a copy of my summary? Mr. Hall, I hope I captured all your comments correctly. Mr. Hall, are you okay talking about your comments?
Sure.
Okay,
Appreciate it, Jocelyn.
Sure.
And I'm not going to go over everything in our comment letter. Hopefully, it was self-explanatory. Happy to answer any questions you might have on it.
okay.
I also did have a chance to look at what you sent that incorporated our comments. I think it's accurate. Just the two caveats I would say is for, make sure I get it right, 845E. I mean, we did suggest that last section after the comma could just be deleted or reworded as you've shown here. So it said subject to the right of the party, I think, with the burden of proof to present responsive testimony. We suggested that could just be deleted, but then we offered some additional language. And same with section F, we suggested that the entire section could be deleted or to include the alternative language that we provided. And again, like I said, won't rehash all of our comments. Happy to answer questions. I think the gist of our comments is that, Act 41 does not mention surrebuttal or responses to surrebuttals. We felt like the proposal was sort of creating this new type of testimony that was sort of overly broad interpretation of Act 41. We believe it's pretty clear that responsive testimony for a utility company would be essentially its rebuttal, and that they would then be allowed to present that last, which Duke has done in its most recent rate case. Some of the other concerns we had with the proposal were that it would not necessarily limit any additional testimony to responding to new matters, and would not limit what's in that testimony as provided in the South Carolina Rules of Evidence and Rules of Civil Procedure, and some of the case law that's been cited, that essentially a party may be able to respond to new matters that come up, but they shouldn't present things that should have been in their case in chief, and that there's discretion for courts in what to allow. And in this instance, we believe the proposal would sort of eliminate all commission discretion.
Okay.
So I think there might be a few other points we made, but again, won't go everything. Happy to answer any questions.
No, I didn't. I understood from your perspective. You felt that what you proposed more closely aligned with Act 41 of 2025. Thank you for catching our error. We're B and C, where C should have included the request for production instead of written interrogatories. But I really didn't have any questions, and my reason for not striking part and leaving a part, I thought maybe your preference would have been just to include, for example, under F, the reference to the rules of civil procedure and the rules of evidence versus that's why I did that way.
Yeah, I mean, I think our first recommendation would be just to delete it. That the changes that are proposed in, I think the order of witnesses
845. Order of procedure is 842.
842, the order of procedure.
Oh, okay.
There allows the applicant or petitioner, those with the burden of proof or the complainant, depending on the type of case, to open and close its case. And we feel like that
it was sufficient.
That's sufficient. Yes.
Okay. But you don't have an issue with the draft as it was published today?
No, that was our alternative recommendation.
All right.
So we'll be fine with that as well.
All right. Thank you. All right, Mr. Hall, if it's okay now, I'm just going to go back through the other stakeholders and ask if they have any comments. Dominion Energy, South Carolina.
Sure. And Roger, I was having a little bit of a hard time hearing you because of the air conditioning system. So if I ask you a question, you answered it. Sorry about that.
No problem.
Jocelyn, some minor things in 833B and 833C. The last addition, unless a shorter time period is agreed to by the, and then there's a parenthetical, responding to the interrogatory and or unless the time is extended or shortened. Those terms have distinct things, meanings. I think what you're asking is the parties can agree to shorten or the commission can order it shortened. Yes. So I would recommend just dropping the and slash and just have B and C just be or. Yeah, a comma after things and then or unless shortened. And then I think I understand the parentheticals, but I just want to be clear.
Okay, sure.
It says agreed to by the parentheses applicable party serving and parenthetical Department of Consumer Affairs, parenthetical responding to the interrogatory. What I think that means is agreed to by the applicable party serving and responding, and the parenthetical about DCA is just that they proposed the idea?
Yes, that's okay. Correct. Because I couldn't think of anything else this morning to make those words stand out.
No, I just wanted to make sure that we didn't have to get...
Yes, but it'd be hard to read, but yes, you are correct.
We just want to make sure that we didn't have to get DCA's consent to shorten their time to respond to interrogatories. I think Roger was speaking of this in 845... E, that's already in Act 41, so don't really see the need for E. And then F, I think, Roger, did you say you just delete F? Is that what you...
That was our first suggestion.
Instead of what's in the suggestion.
And what's there was our alternative suggestion.
Subject to comments from others, I don't think F is needed either. Act 41 defines the parameters of responsive testimony, gives the applicant the right to do it. I'm not sure I quite understand the references to 43J and 611D, putting restrictions on the ability to file responsive witness testimony. Act 41 just says it happens if they want to do it. It's in the discretion of the party with the burden of proof. So I think we align with just deleting it and let Act 41 control as drafted by the General Assembly. But if we need further discussion on the alternate language, if we could get some better understanding of the inclusion of those two rules, that would be helpful. That's all we have.
Okay, thank you. All right, let's see. So I'm gonna skip you for right now, unless you want to add something.
I mean, I don't mind following on unless you just want to go through the rest of the parties, or I can follow up on Mr. Anselmo's question.
All right. What's most efficient for you? Probably right now, while it's on your mind. Okay, please.
I think the main point, Michael, is just that the limitations in 43J about not introducing new matters, that wasn't necessarily accomplished by the original proposal, that there was no limitations on what could be presented in a quote unquote responsive testimony. So we thought that was pretty clear. And if you look at some of the case law cited in our comments, I think that reflects that as well. And there was 611. I think part of that was that you have the right potentially to recall a witness if there's a new matter that comes up. And I think there was part of the proposal that didn't necessarily limit responsive testimony to new matters, but also that there's some discretion with the courts under that rule that wasn't present in the proposed language.
And if I understand your proposed language, thank you for that. The only party who would have the option to do any of this responsive testimony, I think we all agree, is the party with the burden of proof.
Yeah, I think subject to just the right of any party to recall a witness, depending on what might come up during a hearing. But generally, I think that the goal is to accomplish that for the party with the burden of proof.
Gotcha. So I appreciate the clarifications. The company does part company with that interpretation of Act 41. Act 41 says the party with the burden of proof must be permitted to open and close its case, including the presentation of responsive witness testimony. General Assembly didn't give any other party the ability to file responsive testimony. So this alternate language would deviate from Act 41 and expand upon it, which, as you know, Jocelyn, that can't be done in the form of a regulation. So I think the best course of action is to follow Act 41, strike the alternate language, and roll with what the General Assembly told us.
Okay. And okay. I was going to ask all of you, do you still think though, do you think Act 41 prohibits the commissioners from recalling a witness if they see the need later on? Do you think that that's restricted to that? I'm not talking about the parties in the case. Or you may need to think about it, but I heard what you said, Mr. Anselmo, and I was just curious about the commissioners. We can talk about that at another time or when the issue arises in a hearing. I was just curious.
I think, well, I'm not going to think. If you read Act 41, it was directed to the parties. There are some things about what the commission can and can't do, but for this specific area of testimony, it was applicable only to one party in the proceedings. I think the commission always has, as courts do, inherent authority to recall witnesses, subject to the ability of the party whose witness it is to be able to maybe take a break and talk to the witness before they take the stand. Obviously, once they're sworn in, and if it carries over the next day, we can't have any dialogue, but we have to have the ability to talk to our witness in advance of being recalled.
Okay.
What's that? And redirect.
Okay. All right. All right. Thank you, Mr. Anselmo. Thank you, Mr. Hall. Mr. Richardson, do you have any comments at this time?
No additional comments at this time. Thank you.
Thank you so much. All right. Mr. Welborn.
Hello. I think we say this every time, but I did want to start with our appreciation for your work and the work of your staff and trying to, work through the Act 41 changes to the procedures. And I think Duke Energy and the commission have the same goal, which is to effectuate Act 41 best we can so that we stay on the right side of that. So appreciate y'all's work on that. We did have a quick opportunity to review what you had sent around this morning and had some, if we keep, I guess, subsections E and F to 845, some friendly amendments that we think brings it back closer to the Energy Security Act using some of the language from that. And I can, if it's all right, pass that around now.
Okay.
A quick print. I don't know if you saw me jogging into the
I did.
the hearing. So that's what I was doing.
Do we need some more copies?
No, ma'am. I think
we
we have.
Okay. And what we can do, Mr. Welborn, if you want to, we can place it here on the dot camera as you are talking, and the virtual participants can see if you'd like.
Yes, ma'am. That'd be great. Thank you. I have it up digitally.
Yes, you may. Watch your step. Thank you. Is that okay, y'all? This one right here, the dot cam. Okay. Let's see if I can zoom in. Would you all like to zoom in back in the back, or you want me to try? All right. Virtual participants, can you see that information?
Yes.
You can? All right. Okay, Mr. Wilburn, I've
Thank
heard
you.
the indication they can see.
And thank you for putting that up on the screen for us. Again, I think we have more consultation to do with the company in terms of whether it would be a better effectuation of Act 41 to just strike the additional regs, or to include some accommodating language so that it's closer to the Energy Security Act. My personal instinct, just based on the confusion, is that some regs could be helpful, so that we have a go by. There appears to be some disagreement as between the DCA and the other parties, and what the clerk had posted to the docket. So in that regard, it may theoretically be helpful to have a regulation that provides a little more structure and guidance. But again, I think I need to bring that back to the client and come back or file some maybe follow-up comments,
Okay.
if that's all right.
That's
But
perfect.
just going through this real quick. So in E, we've just grafted in some of the Energy Security Act language, which recognizes the right of the party with the burden of proof to present responsive testimony as part of closing its case.
Mm-hmm.
And so, as you know, that reg subsection E permits parties of record to respond to supplemental testimony, which is all well and good, but it can't impinge upon the General Assembly's recognition of the party with the burden of proof's right to present responsive testimony. And so it's just sort of a sort of a reminder that, okay, supplemental testimony is appropriate and fine in certain circumstances. But at the end of the day, the party with the burden of proof must be permitted to present responsive testimony. Again, that's just grafted from the law itself.
Okay.
Before I move on to F, Lyle, do you have anything to add to E? Okay. For F, the references to specific rules of civil procedure and rules of evidence is awkward, clunky, unnecessary. A party can reference rules of civil procedure, rules of evidence, case law, et cetera, when they make any argument in any case, whether it's a motion to strike or to oppose certain testimony. I think if we were to review each subsection of each regulation that the Commission issues, to think about and graft in, components of rules of evidence and civil procedure, that would be quite an exercise. And in this case, to me, it's not appropriate and not helpful and adds to some confusion. One of the conversations that Lyle and I had this morning is that when you begin to make fact-specific and contextual arguments within a regulation, it can just really confuse and bog things down. And so it didn't seem helpful in this case. But again, we have wrapped in some language to bring it back closer to the Energy Security Act. So we propose to replace provide live responsive testimony with present responsive testimony where new matters or testimony are introduced in rebuttal or arise at the hearing, again, pointing back to the General Assembly's recognition that the party with the burden of proof has the right to close its case, including the presentation of responsive testimony. And so, again, just bringing it back to the language of the statute and clipping out some of the unnecessary qualifiers from, the rules of civil procedure and evidence. Lyle, do you have anything to add there?
Yeah, and certainly recognize we've cited a lot of those authorities in various proceedings with the Commission. I'd note most of them, however, were in the context of opposing surrebuttal testimony because that was a practice that really contravened trial practice and general civil practice. In recognition of that fact, we believe the General Assembly has now realigned the Commission's practice and procedures to allow the party with the burden of proof, which is normally the plaintiff in civil trial practice, the right to the last word. And so we think 43J, some of that might not be necessarily on all fours here, in light of this new specific statute in the specific realm of utility regulation proceedings. And so sort of just engrafting that as a matter of law in the regulation would not be appropriate. And then as for, the rules of evidence, they always apply. In proceedings at the Commission, the chair, as the presiding officer, has discretion over the admission of evidence. That's there. I don't think we need to, again, engraft a specific rule of evidence at the expense of all others, because then that raises questions of, okay, does the inclusion of one imply the exclusion of others? Let's just not go there. Chair can, retain discretion over the admission of evidence. And then we think, again, to Mr. Welburn's point, our proposed revisions to subsection F and subsection E, for that matter, align with Act 41. On this notion of responsive, I did want to at least put our position in the record that, that reviewing it viewing it in a light of being restricted to the company or a utility or any party with the burden of proof's ability to present rebuttal testimony is misplaced and would contravene the rules of statutory construction. So under the Masham v. Karras court case, the legislature's use of two separate terms makes it clear that it intended two separate meanings. The word responsive, of course, is in that sentence, and it says the applicant seeking relief from the Commission shall have the right to pre-file rebuttal testimony responsive to the direct pre-filed testimony of others. Now let's look at the last sentence. The party with the burden of proof must be permitted to open and close its case, including the presentation of responsive witness testimony. That doesn't use pre-file, doesn't use rebuttal, doesn't use anything else that defined that pre-file rebuttal testimony earlier in the statute. Use of two different meanings, or use of two different words means two different meanings. And so trying to limit that presentation of responsive testimony, which isn't used anywhere else in the statute, just by linking it to the happenstance use of the word responsive in the context of pre-file rebuttal testimony is comparing apples to oranges, and it fails as a matter of law and logic, frankly. So the word pre-filed appears nowhere in that sentence, and so we can't read it in there. Also, let's look at the word presentation. How do you present something live? And so I don't think the opposition to that happening live makes much sense when you use the common interpretation and understanding of that word in its context. So with all of that, you know, as our colleagues at Dominion have said, as others have said, the commission can't construe terms in a statute in a way that would expand or limit their meaning. And so with that command in mind, and that's a canon of statutory construction, we believe that our language more closely hews to the Energy Security Act in subsections E and F of the proposed regulations. And as Mr. Welborn noted, we agreed with all the other recommendations that DCA flagged with respect to the discovery and allowing the parties, you know, to work that out amongst themselves, because as he indicated, you know, parties serve discovery among each other. So it doesn't make much sense to, you know, limit their agreement to one particular party in a case. So we're in agreement with all those others. We just respectfully part company on this specific issue. And we think that, you know, to the extent the commission intends to leave these in, and I do agree with Mr. Welborn, I think some guidance would be helpful in this new frontier, then we believe our proposed regulations are more faithful to the General Assembly's intent.
Thank you. Thank you, Mr. Treywick and Mr. Wilbur. Mr. Hall, did you want me to wait, or would you like to respond now?
I guess just briefly, obviously the department would have to look over the additional proposed language. I think part of, as Mr. Treywick alluded to, I mean, part of the reason to include the subject to language that we did is because those rules do apply, and those do provide, I think, the additional guidance that Mr. Welborn and Mr. Treywick mentioned, that if it's going to be subject, I mean, if you're going to be able to present it, the commission should recognize that you can't present things that should have been in your case in chief, and it needs to only be for new matters. The commission just proposed a regulation change recently, if you might recall, on working papers and attorney work product, that I think everyone in this room agreed that it was okay to add that it was as provided in Rule 26 of the Rules of Civil Procedure. So there's precedent for that, and the commission has proposed it. And I don't need to go like tit for tat on everything here, but Mr. Treywick said that it's something failed logic to have the interpretation that we do. Again, there's nothing in Act 41 about surrebuttal. So if we're expanding a meaning by including this response to surrebuttal, the legislature could have easily included that. We showed how they could have done it. They have similar language. And we have also grappled on the last point on the presentation. And I don't know that we need to dive that deeply into it, but yes, presentation is live. But if you think about the uniqueness of the commission and how everything is pre-filed, so the witnesses pre-file their testimony, and then they present that to the commission. So I think another logical way to look at that would be that is you're presenting your rebuttal testimony last to the commission. That's one of the ways we think it could be interpreted.
The responsive testimony could be considered rebuttal.
Yes, and that's the only other reference in Act 41 to responsive testimony is rebuttal testimony in response to direct. So yes, you pre-file it and then you present it live. Again, I'm not saying that's the intent, but I think it doesn't necessarily mean new live testimony. So that's all.
Ms. Boyd, can I flag two things for you?
Okay, yeah.
In subsection D right there, or sorry, it's codified as amended as 58.3.140D. It does say surrebuttal in the sentence right before with respect to the discovery. So there is sort of a recognition of that. And we agree that surrebuttal is discretionary, but, to the extent parties are going to continue filing it, I think this is a recognition of commission practice that the party with the burden of proof should get the last word. With respect to the rules of civil procedure applying, I would note that regulation only applies with respect to discovery. And so that's why we specifically mentioned Rule 26 in that working papers definition. So instead of just wholesale adopting the rules of civil procedure, the commission's done them with respect to discovery. Here we're talking about mode of trial and hearings. And so that is, again, a more specific reference from a statute that would trump a general rule of civil procedure anyway. So no need to limit that by certainly if a party wants to make an argument with respect to Rule 43 in the context of an objection in a hearing, they can argue that as persuasive authority. But again, limiting what the General Assembly's done by statute with a court rule of general applicability, in our view, would not be appropriate.
Okay, I'm looking at that section now. 58.3.140D in Act 41. I see supplemental or new matters may arise. Other parties respond to the supplemental testimony. Then it goes into the discovery.
Mm-hmm. And there's that final sentence.
I see. Okay.
Right.
Okay. So surrebuttal's reference to the procedural schedule for discovery.
Right.
Okay. Okay.
And I would just say that's a completely different aspect than what we're talking about here.
Well, I was just responding because the comment was made that surrebuttal isn't mentioned anywhere. And I think that's a recognition that it has sort of become part of the practice. So.
Okay. All right. Thank you, Mr. Hall and Mr. Traywood. Ms. Mixon and Mr. Gooding, do you have any comments right now or at this time?
Thank you, Jocelyn. We don't have any additional comments at this time. Thank you.
No, thank you. All right, then Mr. Taraney.
I think I agree with most everybody in this thing. I think the Duke language makes sense. If I understand Mr. Traywick, he objects to the reference to the rules of evidence and the rules of civil procedure, but he doesn't dispute that they apply. I mean, he just thinks somehow, as a matter of drafting, they shouldn't be in there. Mm-hmm. As long as he agrees that they apply, that the objections can be made, I'm not sure the parties are really that far apart on it. I do agree it would be helpful to have those two provisions in the regulation just for clarity. I mean, as a matter of course, people look at the regs, and if you leave that out, it just seems like it's incomplete. But tracking the statutory language avoids, any trap of being inconsistent. So I think I'm fine with the language Duke put out.
Okay, that's 845 E and F. Mm-hmm. All right. All right. Ms. Edwards?
Hi. Jocelyn, I think at one point somebody suggested deletion of E and F. Mm-hmm. Again, I would have to take that back as well. I think we would be okay if the commission decided to delete, but I also heard several parties, make mention that it might be helpful for clarification. I do think, in light of the comments that you've heard today, I think an opportunity for follow-up mm-hmm. with written comments. Mm-hmm. I don't know if you need to have another workshop, but at least give some folks the opportunity to look at everything and respond.
Thank you. And I don't think Mr. Witt has appeared. Okay. All right. So now Mr. Muschin.
I don't have anything further, Justin.
Okay, great. Okay. And Mr. Hall, do you have anything else? All right. Okay. So everyone, yes, I was hoping to file just a notice of drafting this Friday because it would be due. But of course, the comment period for the notice of drafting would not end until sometime late December. However, I think that we should come back to the issue, visit the issue of follow-up comments as it relates to today's workshop, if you all don't mind. Now, we're not finished quite yet. Remember, we have one other document to talk about.
Miss Boyd, I forgot a typo type correction
did you?
in one.
Okay.
I just wanted to put it out there. I can't imagine there'll be much discussion on this. In 803, 835, the new language has the party with the burden of proof, comma, including the applicant, petitioner, etc. Frankly, you could drop the entire, including the applicant, comma, petitioner, comma, etc.
Mm-hmm.
But at a minimum, I think the company would recommend dropping the etc. I think we all know, based on the order of presentation reg and basically just the general rules of burden of proof, know who have the burden of proof. But to the extent the commission wanted to leave that in there, I would certainly suggest dropping etc. as that's not really appropriate for use in a regulation.
Thank you.
Sure.
Okay, let me find, I have extra copies too for the additional topics. Virtual participants, are you able to locate, if you don't, are you able to locate the additional topics on the docket management system under docket number 2025-191A? I think they are that's the last document that was. And I have copies in the hearing room. So it should be matter number, once you access docket number 2025-191A, click on matter ID 334466. It's the amended additional topics.
Ms. Boyd confirming that I had found them.
Thank you. Okay, does everybody remember from our last workshop dealing with these topics? It's been a couple of months. We received some feedback, regarding verifications and when they should be filed. And we had some discussion about Rule 11 as it relates to attorneys and filing documents in a form, and they're under the obligation to make sure that what they're filing represents true information, basically. That's my recollection of it. So, may we proceed at this point with just whatever your thoughts are that we may need to clarify this section as to its applicability. Any thoughts that you may have had since the last workshop, we'd appreciate it. So I will begin, Mr. Anselmo, with you and Dominion Energy, or I can call upon you later if you'd like.
No, we're fine.
Okay.
So two things that I think we've mentioned previously. As you said, it's been a while, but I think we mentioned this. On topic one, a pleading isn't evidentiary unless the party intends it to be evidentiary by introducing it at the hearing.
Okay.
So the verification of all pleadings is what's suggested in 822. I don't really understand the need to do so. And also think about matters where you file a application or a pleading simultaneously with written testimony. I don't, so we'd have to verify a pleading or an application and then also have sworn testimonies filed simultaneously. It just seems unnecessary. Again, just because somebody files a pleading in a case doesn't make it part of the evidentiary record unless it's introduced into evidence. So verification of a non-evidentiary document seems unnecessary. Again, I think you should let the party who controls their pleading decide the use of that document. But look, if others have strong feelings, I get it. I just think that is an unnecessary addition to the signature and verification requirement. Topic 2, I think the company's been consistent that not every matter warrants a pre-hearing brief. Proposed order, yeah, I get, but perhaps that could be after consultation with the parties. The presiding officer shall fix a time. What I don't think anybody wants is the commission or the hearing officer, whomever, issue a schedule that says you have to file a brief on X date, and then there's an expectation that a brief gets filed on a matter that nobody's contesting anything technically, or it's just simply unnecessary.
Mm-hmm.
Single issue cases, customer complaints. I mean, so I think flexibility again on the party wanting to file a pre-hearing brief is sufficient, not making it mandatory. And then topic 3, that seems to align with the changes to statute, so no
Yes.
issue there.
Okay, and so may I ask you a couple?
Sure.
Just, everyone, this is for just wants to determine how much information or how you can provide some enlighten, for example, the information that we provided. For example, in 103.822, where you stated that the pleading is not evidentiary unless a proceeding is held. What about those issues where the commission doesn't, and that's quite a few cases. That occurs in quite a few cases where the commission makes a decision at a commission business meeting and a hearing is not scheduled, or a hearing has been scheduled and the party asks for expedited review. And typically verified testimony is provided so that the witnesses who would have been live in some form state that what I provided is accurate.
Yeah, my recollection is the regs require testimony that is not introduced in person at the hearing, like we do with the scripts, if you will, at the beginning of a hearing, to be verified. Mm-hmm. So, for instance, if I'll use Duke's recent rate case, some witnesses presented testimony, it was introduced into the record, some they filed verifications.
Right.
So if it's not in person and introduced in evidence, but you need it to be evidentiary, you have to verify it.
Okay.
But again, that is up to the party who wants that testimony to be part of the evidentiary record to verify it.
Right.
So the commission can base a decision on it. So I think a reg already accomplishes that. I'm not trying to overcomplicate this. It's just that
I didn't take it that way, Mr. Anselmo, at all. Just trying to determine.
Yeah,
for example, sometimes companies may ask the commission for an accounting order. And the commission makes, Mr. Burgess.
Yeah, Jocelyn, actually, that's the example that jumped in my mind when you were asking your question. And you're right, there are times when the company will file a petition for an accounting order or something similar.
Right.
There is no direct testimony. Historically, the company has filed that under the signature of a lawyer.
Right.
Obviously, Rule 11 implicates that. If the commissioners would like that particular petition verified because it has facts in there just for comfort, I don't think the company would have any objection to filing a verification for a matter such as that.
Okay. All right. Thank you both, but that's where I'm going with this. Commission decides quite a few issues. Are you of the opinion, though, that an attorney is able to provide a verification?
I think our rules of ethics and Rule 11 of the Rules of Civil Procedure provide for that exact thing to happen. I've heard some dialogue at commission business meetings where there's been some questions maybe from certain commissioners about that. I think verifications can be helpful for the reasons I said earlier when you're submitting testimony. It has to be done under the regulations like that. But Rule 11, that is what you're doing. This isn't Michael Anselmo filing something that in-house counsel and the company, the client itself, has not already reviewed and signed off on. Things in a letter are vetted thoroughly. Right. And that's why Rule 11 exists, and there are penalties for violating Rule 11.
I do think it's not the quarterly reports, but maybe they are. There are some type of financial reports when they are filed from some utilities. I don't remember if it's a verification or like an affidavit, and so those are filed, you know.
Those are just quarterly surveillance reports that the commission doesn't take any action on,
right?
And those are indeed filed with an affidavit from an officer in the company. And if my memory is correct, there's some probably long lost letter from a prior executive director who required that,
Right.
and the company has adhered to that over the years.
Yeah. Would it be helpful if the commission needs or wants it to, would it be helpful to have a list of those for the commission, I guess, to issue an order that it would like a verification if it needs, instead of case by case, but as I said, if you were to review the data from the commission's directives which led to orders or directive orders, I would say, you know, the majority of our orders, whether they are directive orders or orders, a hearing has not been scheduled. The commission basically makes a decision on Thursdays primarily based on those filings. And so I'm asking that because I think a number of the commission's cases are decided without a hearing where someone is administered an oath. And would you think that it would be your preference as a practitioner here for the commission to state, look, when an attorney files a pleading, we'd rather have a verification filed with that pleading if a hearing is not required by statute, by a commission order like PGA's, that's an order. Okay. What do you think, I'm not saying it is an issue, but what do you think, what tool would be most helpful for the commission to enlighten or provide its thoughts as to when it wants a verification beyond the attorney signing the document?
Sure, yeah. You know, I think in those instances, it would probably be difficult to come up with a laundry list and include everything where you say, items under Section A all require verification, items under Section B do not require verification. I think it would be easier to handle the matter where you let the parties decide what they want to file and how they want to file it. And then if the issue is, because there are things that are just what I would call routine, mundane matters where the company has to get some type of action out of the commission to do something that not in and of themselves require verification. I think it really should just be up to the commission as to what its level of comfort should be as to what it thinks it needs to do its job.
Okay.
I'll use myself as an example. So sometimes we make letter filings, and one that comes to mind recently is a contract for electric service that required approval by the commission.
Correct.
That's just a letter where I've sat down with the client, went over the contract, understand what's going on. The regulation requires us to make the filing, and the request is made under my signature. That's an instance where I don't think that the commission would necessarily need someone to verify the facts of the contract. The contracts is attached to the letter as an exhibit. But that's just, I'm not a commissioner.
Right.
There may be a commissioner on there who says, you know, I would like for the president of the company to swear to me that everything Chad wrote in his letter is true and accurate, and that everything in this contract is true and accurate. Okay, you're the regulator. You get to decide that issue.
Okay.
That's a basic thing, and I think you have matters of varying degrees where you kind of start at like in my mind, a simple contract filing, and then we can go all the way up to some of the most important matters. Or they're all important, but maybe more important matters up to a rate case or a citing act for generation. I mean, it just has varying degrees of difficulty, if you will.
Yeah. And
I think that it should be the commission to decide whether or not they want something verified at the end of the day. It's not a difficult thing to do to go sit down with someone and say, hey, I need you to sign this affidavit saying all this is true and correct. But again, it's I think it's really just a matter of what is the level of comfort that the commission has. You've got a letter signed by corporate counsel or outside counsel who appear before the commission on a regular basis. If you think you need more than that, then the commission could certainly tell us they need more than that. And that's happened on occasion.
Yeah.
There have been instances where a request has been made that, hey, would you please verify, something, and the company doesn't.
I appreciate both of you. Mr. Anselmo, you have something?
One
to
more
add?
thing to add. There is a burden on verification. And to use a really good example of this is an interplay with a new change that got made recently. Company institutes a rate proceeding by filing an application of pleading, right? It's a long document that pulls in every business aspect of the company. And now, under the regs, you have to file minimum filing requirements that cover an inordinate number of topics.
Right.
You, in theory, could need hundreds of people to verify something of that nature, when perhaps those things aren't even going to be part of the decision-making process before the commission. So could the president of the company sign a verification? Boy, it would take a lot of effort to perhaps educate somebody up. So these things aren't as simple in every case as sign of a verification, you're good to go. That's why as attorneys, we take our Rule 11 obligation very seriously. And I'd also like to state that the reg as written, without the new yellow highlighted part, already says that the signature of the person or the attorney attests to the factual nature of the allegation. So, again, not trying to complicate the verification. It's just not as simple, I don't think, as everything needs to be verified.
Okay. Your sentence before you ended, you said that it says that the attorney is basically admitting that the pleading, as far as the attorney knows.
Yeah, the signature to the person or the authorized representative, for instance, me or Chad, submitting the pleading, or sometimes actually we've seen some filings with business people filing it, the requisite report, shall constitute an admission of such person or representative has read the pleading and knows the contents, and they're acting in the representative capacity, and that we have the capacity to sign it. So it's sort of that is, in essence, Rule 11 in a nutshell.
Okay. Thank you. Dominion Energy, South Carolina. Attorney Hall, do you have anything?
Nothing really. I agree with everything that Dominion just stated. When I first saw it, I did wonder sort of what the impetus for this was. The question, I think I had more questions than anything. It said within the knowledge of the person filing the pleading. So, I mean, in DMS, I think only attorneys are supposed to be filing anything. So is this always on the attorney? That was just sort of a question I had. Or is this a witness's testimony? Are they the one? Who is the person filing the pleading? That's been alluded to with Rule 11. I had to pull it up because I know there's a little bit of nuance. Essentially, an attorney signing is saying that, I've read it, and there's good grounds to support it. Not necessarily that it's true. Where it gets into affidavits and verifications in Rule 11, that's what it says, not just an attorney, but it could be a declaration by a party or his attorney or of a witness. So there you've got, again, Mr. Anselmo said, a witness that can verify something, but depending on the pleading, it may be numerous witnesses. So I certainly understand their concern. For thinking about the department's filings, most of the time it's not going to be a big issue, right? We're going to have one witness that put together the testimony, or it's limited, but with the amount of information the companies submit, I certainly see why that become burdensome.
Maybe the filing the pleading part. Because I think we discussed this briefly in August. The attorney is acting in a representative capacity. They're not going to be placed under oath. They are representing the person who actually either maintains those records or, inspected a site. Is the attorney, I see your point, filing the pleading, and maybe that's not the best word there. Those aren't the best words there. Because unless the person, if I'm representing someone, if the facts that someone else tells me, what am I gonna, if they tell me they're not true and I continue to represent them, am I gonna somehow violate the attorney-client privilege? I'm just trying to see, you understand what I mean?
Yeah,
Because
I think you see
I
that
can't
word.
say anything else if I'm in a representative capacity and doing my job.
Yeah, where you might see an attorney that submits a summons or a complaint or something that has their client submitted verification with it if they think there might be something.
Yeah, I mean,
something that they're not willing to stand on their own and say. But as Mr. Anselmo mentioned, I mean, between Rule 11 and what's already in the commission regs, attorneys are, submitting some authenticity. They're putting their name on it regardless. But again, as to the truth of every sentence is in that pleading, that they may not have that firsthand knowledge always.
Ms. Boyd, Roger raises good points on this, and it brings me back to one thing I think that maybe I should have led with, which is when I, as the attorney, file something on behalf of my client, the client is the corporation, okay?
Right.
Every employee of the corporation is merely an authorized representative, just as the attorney is.
Okay.
So the verification isn't, on some level, that the person in charge of maintaining VC Summer's nuclear inventory. It is the corporation telling you that our record says this is the VC Summer, nuclear inventory, for lack of a better term, right? So what we're missing is when you're representing corporations, nobody except the corporation is the client. Everybody's an authorized representative. So you end up in the same place where whether you file these things and they're put into evidence either through a paper filing proceeding, which we've talked ad nauseum about in other dockets, or orally at the thing, everybody is then, the commission has what they need to rule on the docket based on the specific nature of that docket on behalf of everyone's client, the corporation, right? So you also get into levels of who has the requisite authority to bind a corporation. I mean, I don't want to get in all those levels, like you have the fights under Rule 4 in the civil courts about can that corporate secretary accept service. Look, there are only certain people who are designated to act for a corporation. Some of them are, in fact, the outside counsel and inside counsel of an attorney, of the client. So again, one size fits all on this is really difficult. And I understand the need for the commission to rule based on accurate financial or factual information, but other rules of the commission and of practice already accomplish that fact. It seems like this one is being drilled down to a granular level that's making it a little more difficult than I think it needs to be.
So I think the question, if I may say, is maybe it will make it clear, not just for you all, but maybe the intent. I don't think any of us, I don't recall this regulation 2007. So I was here. I don't know why it was amended. I don't recall, everyone. I don't know if the administration of this regulation would be better if it says a verification under oath shall be required of facts alleged to be true within the knowledge of the person filing the pleading, either as requested by the commission. That's where I'm going with this.
May.
No? You said no?
No, I think we're all saying may. To Chad's point is, if the commission thinks they need a verification, tell us. We can endeavor to get that in as quickly as possible.
That's where we weren't trying to belabor this issue. The question from my perspective is, how can this regulation be, its intent, the wording in the regulation is as clear as possible. So we're not, I have my perspective, but from your perspective, is it already clear enough as to who needs to file a verification? Would it be helpful if this is included in the next round to say at the end, as requested by the commission? Or are you fine with the wording now? Because it doesn't say. Okay. Yes, Mr. Traywood?
Sorry. Just a suggestion. I think we could change it to may.
Instead of shall?
May be required if requested by the commission at the very, if requested by the commission at the very end. and again, it's to preserve that flexibility and not to go out of turn. But I do want to clarify that courts decide cases on pleadings all the time, right? And so that is facts alleged and signed by an attorney, right? You can move for judgment on the pleadings. You can move for summary judgment. You can, move to dismiss. And so I don't think there's a problem in and of itself by deciding an application, particularly one in which ORS files a letter of no objection, right? If there are no facts in dispute, I think the commission can decide that case, so to speak, on the pleadings. And so no verification is necessary. And so what this would be is an odd situation in which maybe there are some disagreements by way of comments or maybe something else. And the commission, just to get some more, get more comfortable with the record and making a decision thereon, would desire verifications, then preserve that flexibility, but also not, require the more onerous thing of verifying everything, like, for instance, a rate case application, where, to Mr. Anselmo's point, that could require some serious studying up to get one person to verify the entire thing. So I think we're all trying to accomplish the same thing, and that would probably be the easiest way to do it.
Okay. So yeah, that was the intent of including this back in August. And the purpose today is it as clear as possible of what is required with the current language? Is it confusing? Can it be better? The language, the wording, can it be better? And if someone were to read this, would they understand? Okay, as you just talked about, Mr. Anselmo, will the verification need to be filed with everything? Is that clear now? If it's not, do we need a list? No, we don't need a list, but maybe the wording perhaps can be strengthened. Maybe. If we'll hear from everybody else. Mr. Hall, you have something else for that? All right. Mr. Richardson? Oh, hold on, Mr. Richardson, for me for 1 second. So I need to go back to Dominion, please. Dominion Energy, please. This topic 2, what we wanted to ask there, where we've highlighted the presiding officer shall fix the time. I want y'all to know that highlighted language, not just for y'all, especially for me, so I can remember what we're supposed to be talking about. We want to ask, let's say someone does want to file a brief or proposed order. Should they have to wait? And you remember we talked about this a couple months ago. Should they have to wait for a presiding officer, or can it be, as Mr. Anselmo mentioned, after consultation with the parties, or after consultation and agreement among the parties? Or the presiding officer, given that flexibility, that's my reason for asking that. That's why that language is highlighted.
Yeah, flexibility, I think we all agree with. I see Roger nodding, Lyle was nodding. Look, as drafted right now, the reg says you have to wait for the presiding officer to fix a time. Some people don't want to use briefs. Some people do. I think just changing that to may, after consultation with the parties, fix a time. Again, I think we've all said this at various times at this hearing. I can't remember seeing many cases, if any, where pre-hearing briefs were used. So giving this flexibility probably makes sense for each specific case.
All right, so the presiding officer may, after consultation with the parties, fix the time. Okay, I got it. All right, last thing. The reason the Siting Act like facility is on is because we really wanted to talk to Office of Regulatory staff about a suitable time for placing those requests on the commission's agenda. That's why that item is on. Do we need to wait a month so that we kind of routinely add the item to the commission's agenda without having to bother ORS every time? Okay, now I need to go back to you, Mr. Hall. Any further comments?
No.
All right, Mr. Richardson.
Thanks, Ms. Boyd. I believe the points about trying to keep things, on an ad hoc basis as far as when to use verifications and relying upon Rule 11, agree with those statements, so no further comments from me.
Thank you. Mr. Trawick and Ms. Henderson.
Thank you. I think we sort of expressed our comments on topic 1 out of order earlier, but I think, again, everybody's sort of aligned on that. And I actually take Roger's point, too, earlier about the sort of who's submitting or whatever. To align with Rule 11, you really could just say signing the pleading instead of submitting. And that would sort of remove any ambiguity about, all right, is it the person
All right.
filing or whatever? And I think that might solve any potential ambiguities there. And with respect to topic 2, as Mr. Anselmo indicated earlier, I think, again, just preserving flexibility there, you could change it to say the presiding officer may fix the time for filing and service of briefs or proposed orders after consultation with the parties. As a practical matter, in most proceedings, we all, as counsel, tend to conclave with Ms. Wessinger Hill after the hearings are over and discuss, hey, how long do we need for proposed orders? What's our thinking about timing for the transcript? Because, obviously the transcript's very important for the preparation of those documents. And so I think just preserving that flexibility. And so I would question, Ms. Henderson raised a good point earlier, presiding officer, can that person act, is that the chair? And are they acting through the general counsel or staff counsel to the commission to communicate that?
Mm-hmm. Our regulation, I think it can include a commissioner. I think it can include 103, 804. It defines a presiding officer.
Right.
And I think it's broader. It's very broad.
And I think that the chair, as the presiding officer, could act through counsel too, and she could sort of report back on that. But I just want to make sure the flexibility is there, because I think that process has worked really well for both the commission and the parties to sort of communicate the needs, work within statutory timeframes, and work with our very hardworking Ms. Wheat to make sure we can all have the transcript and include that in these important filings.
So presiding officer is a commissioner or a hearing examiner appointed and duly designated by the commission who presides at proceedings before the commission. So maybe that part does need to, thank you for bringing up that word, because this limits the presiding officer to a commissioner. Well, a commissioner can delegate that responsibility, or a hearing examiner.
You could say the presiding officer or his or her designee.
Yeah.
And I think that might solve the concern and be appropriately broad to give flexibility.
Yeah. Thank you for bringing that up. Okay. Anything else right now?
Remind me, topic 3.
Okay. Topic 3 is we have 60 days. So we just want to know what's a reasonable amount of time after the application is filed after it's filed for the commission to place the light facility application on its agenda for disposition.
Yeah. Got it. Well, yeah, I think the statute speaks for itself. I'd certainly welcome Mr. Mushin's thoughts, because, RS needs time to conduct its review function and,
Right.
Determine whether it has an objection or any additional comments or recommendations. But, so long as we're all following the prescriptions in the statute, I think, that makes sense here.
Okay. Thank you so much. Ms. Mixon and Mr. Gooding.
Thanks, Jocelyn. We don't have anything else to add.
Thank you. Mr. Terani?
I hate to, I'll make this quick. I hate to flog this
Okay.
mule further, but I think you ought to delete 103.822 altogether.
Say that again for me, Mr. Terani, please.
I would delete 103.822 altogether.
All right.
I certainly don't think you need to add that sentence. I've always taken 103.822. I've always treated it as the functional equivalent of Rule 11, but if you read it, it's not Rule 11's language. But certainly to add a verification, one thing to keep in mind is think of all the telecom filings that are made routinely without counsel. So you definitely, the ad hoc verifications altogether, you don't want to have you want to have verification if the commission wants it. But, Rule 11 has a provision for a pro se person signing, contemplates a pro se person signing, contemplates an attorney signing, and both of them say basically that the signature constitutes a certificate that he has read the pleading, motion, or other paper, and to the best of his knowledge, information, belief there is good grounds to support it, and that is not interposed for delay. It specifically says, except where otherwise specifically provided by rule or statute, pleadings need not be verified or accompanied by an affidavit. So, we have this regulation that says 103-822 signature and verification. I think it directly contradicts the rules, but I'll stop there. On topic 2, there were 2 things that I had a question about. One is the exhibit reproduction. Certainly don't have any problems reproducing an exhibit in an appendix to the brief. I would hope that that rule still affords us the discretion to reproduce the exhibit in the brief as well. So sometimes it's easier to just show a picture, and say, this is what we're talking about. This was exhibit 1, and just reproduce it inside the brief.
Yeah.
I'd like to know that we can do that. Finally, the 10 copies is.
Let's see. Oh yeah, that'll need to be deleted. You're right. In E, the last sentence. Yeah,
Do we still
definitely.
want that? And I don't have any comments on the light facility issue.
And Mr. Terraini, is there anything that we can do? I see it says maybe reproduce and not shall. Is there anything we can do in D to clarify that it's allowable? It would be allowable for the exhibit to be reproduced within the brief?
Well, I don't mind if you want it in the appendix. If you want an appendix including the exhibits, fine. I don't even know if you need to say it. I just would like an understanding that you can also discuss the exhibit, or you can also reproduce it inside the brief.
Okay.
So in other words, 2 ways,
All right. Yes.
I'm not sure how to wordsmith that, or if you even need to wordsmith it. Because as a matter of course, people do that. So.
Thank you.
Okay, thank you.
All right, let's see. Miss Edwards.
Hey, I don't really have anything more to add other than, like, for example, we just recently, you may recall, filed affidavits for our ETC designation. So there are some other regulations where, depending on that particular filing, it specifically requires us to do actually an affidavit, because the commission in turn relies on our representation to then turn around and give the authorization to the Federal Communications Commission. So just FYI.
Thank you. Mr. Mustian?
Yeah, just a couple things. So, topic 1 and 2, as I understand it, these regs have been around for quite some time. I don't really know that I've ever seen any major issues come out of that, but certainly understand the need to update it, and don't really have a problem with anything we've talked about so far. As far as the signature and verification, and I won't belabor that point, and this is kind of really more of a question. So we received, I think, the testimony filing letter in a case recently, and the clerk's office, the commission, asked for testimony to be verified when it was filed in that case. My assumption on that was, and this is just generally more procedural, is that's a situation where, as part of the application, there was a request for a waiver of a hearing. And so my assumption was that's not necessarily going to be across the board every time pre-file testimony is filed. That's more of because there is a request for a waiver, assuming that waiver is granted, then that testimony would need to be verified because it does allege facts or assert facts and all that sort of thing. So it's really more just of a clarification question. Is that, does the commission anticipate all pre-file testimony needing to be verified, or is it in situations specific to where either a hearing is not required or there's a request for a waiver of a hearing. I don't know if you have any insight on that.
I would, based on my historical knowledge, I have seen it more often than not on a consistent basis asked when a hearing has been scheduled and the hearing the commission's considering waiving the hearing or waives the hearing, and pre-filed testimony has been filed. So they will ask or can ask for verification because of the event that they anticipated, witnesses being present or to be administered the oath is not going to take place.
Right.
So if that particular case was scheduled for hearing or a hearing is typically held in those type matters, I would think that's why you were asked or the parties were asked to provide verifications.
Yeah, and so kind of along those lines, like, and not that we file many petitions, but rule to show causes and things like that.
Yeah.
We will include an affidavit. I think we usually use an affidavit instead of verification, but in any event, in the anticipation that there may be either a motion for default judgment or asking to rule on it without having a hearing or something along those lines. That's how I've always kind of read that section is that is when and it's not necessarily a verification. I know it says person filing the pleading. I've always kind of interpreted it more of when you've got a fact witness or an affidavit or you're attaching testimony or something along those lines. So that said, certainly have no problem with what's been discussed here today.
Okay.
With respect to the third one, I think I'm sure my folks will strangle me when I get back, but I think 30 days is fine. If we do run into an issue, then we can certainly reach out to the commission and let them know. But but I think the like facility requests, we've been jumping on those pretty quick. Usually can get those wrapped up in 30 days, I think, as a normal course. So I think that makes sense.
And you're okay with just if you see it on the agenda, you're not ready, you'll file something saying such.
Yes, absolutely. And I mean, it does, I don't know that we need a regulation specific to that,
Right.
but it is helpful if we do have a little bit of time to process it so that, we're not looking like, we don't want the commission to look like it's delaying. We certainly don't want to delay. Sometimes things come up, but if we have a little time to process it ourselves, then yes, that's very helpful.
Perfect. Okay. Y'all, I'm going to quickly, because I think I have everybody present, we talked about two things. Thank you all for your feedback. If anything from the additional topics that you may see referenced in the notice of drafting, it would just be topics 1 and 2, as we discussed. Okay. I would not, of course, include topic 3. Those were there for my notes so I could remember that I need to talk to you all about it. Okay, follow-up comments. So it's the beginning of November, and we do have some activity going on at the commission over the next couple of weeks. Would you all like to file comments by, let's see, the first week of December, second week of December, so that we can kind of see your thoughts after you've spoken to your clients? So we can either move to December 10th if you'd like, after you talk to your clients, to see if you have any additional comments beyond what you stated today, or if you want to reiterate what you stated today. Does December 10th work, or December 12th? That's a Friday. Any thoughts? You good?
Just to clarify, is this
Sure.
on the sort of blended proposal of DCA and Duke on those?
Yes, please.
Yeah. Okay. I don't know that we need that much time.
Okay.
But,
Well, let's see. You all have a case starting some of your.
Yeah, a couple things going on.
Yeah, the couple of days. So I was trying to. Why don't we say December 5th then? If you all don't need that long. Okay.
That works here.
Friday, December 5th. And staff will appreciate receiving whatever additional comments any of you may have. And then after that, like I said, I'm trying to file a notice of draft and get this process started. So everybody's maybe as clear as we can be. We're looking at the notice of follow-up workshop. So that's going to include 831, 832, 833, 834, 835, 842, 845. Because regardless, I know we were talking about E and F, but there's still some other changes that nobody, for example, in 845, I didn't hear any objections, so 845 still has to be addressed. And then 846. Then we will have also 822 in some form or not, and then 851. Does that make sense? Okay. In this initial draft. You've probably been paying attention to DMS, our 5-year review time period to review our regs again is arrived. So we'll be doing that too, y'all. But this, I'm trying to move these in a separate phase forward. Last thing, before we start on 2025-192, Dominion Energy South Carolina, Mr. Richardson for Piedmont Natural Gas, Ms. Henderson and Mr. Trawick for Duke Energy Carolinas and Duke Energy Progress, Mr. Terraney for Nexus Water Company and ORS. You all are all the participants I have for 192. Are you okay with us starting, let's say, around 1140? I know the notice said at the conclusion. Please leave that running. Please leave it. We're still going. Continue the live stream.
Yeah, we're good.
Done. Okay. Thank you. You're okay? Okay, so I'll see you back around 1140. Thank you.